Well, it's a great pleasure to join you virtually for your forum on financial and banking disputes. I am happy to participate virtually and share a bit of the experience that we've had in Hong Kong as well as globally on the use of arbitration as well as mediation in banking and financial related disputes. So today in the next 20 or so minutes, I'm going to share a bit of background on how the system was set up in Hong Kong, what was learned from other jurisdictions, what are some of the benefits, and then hopefully you'll get a chance to do some role play at the end. So, uh, in terms of the background, um, we're going to also look a bit at the design of the system, the arbitration system for financial disputes in Hong Kong. In terms of what we have in relation to Bangladesh, I understand from doing some research about the current system of civil litigation in Bangladesh that you have quite a large number of cases pending in the courts, 2.1 million from one piece of research I read, and that quite a large percentage of individuals, claimants, as well as users on both ends are not satisfied with the court process, roughly 60 to 70%. And quite a large portion of the population is including those who bring cases to trial, find that the court expenses are exorbitant or cannot bear them. The length of resolution is approximately 1,442 days. And in many cases, the litigation cost is 66% of the claim value. So I'm sure, as all of you are aware, you're here because you're looking at other alternatives, options, experiences to consider what might be relevant in the context of Bangladesh. So in terms of global trends, we do see that financial dispute resolution centers exist in most parts of the world, particularly in developed financial centers. So we're seeing the emergence of these centers in China and well-established centers as well in Singapore, in the UK, the US, Australia, Japan, Hong Kong, and also now South Africa. I was recently there to discuss the development of financial dispute resolution system there. So what are some of the benefits? Why are countries adopting these systems? Well, the first is access to a clear dispute resolution mechanism. People often in the context of commercial disputes need to know how and where and in what form they're going to resolve their issues. This has also the added benefit of increasing confidence in the financial service providers and also in the products that are being sold by the banking institutions. The final or the added benefit is that the reduction in dispute resolution cost and time, if any, do get passed on or have the potential of getting passed on to consumers in the form of lower fees, making products, again, more attractive to users. So in Hong Kong, we have increased use of dispute resolution mechanisms across the board in civil justice. We had a practice direction about 8 to 10 years ago that requires some attempt at mediation prior to civil litigation. But in terms of the use of financial dispute resolution, this really emerged following the financial crisis in 2008. We had a mini bond Lehman mini bond related issue here that gave rise to a need for some alternative mechanisms. So just by way of background, this mini bond in Hong Kong was a complex CDO instrument. It was sold to retail investors. Following the collapse of Lehman, these CDOs lost their value, and so individuals had no knowledge of where they could go to resolve these issues, and so they took to the streets, and there were large public protests. The question that the courts had to deal with was whether there was sufficient disclosure on the risks associated with these CDOs and whether it was suitable or the marketing disclosed enough information and whether these are suitable for retail customers. So there were a few responses that were taken. One was a mediation and arbitration scheme under the Hong Kong Monetary Authority. It worked with our Hong Kong International Arbitration Center to address these systematically through mediation as well as arbitration. and the costs were shared between the Hong Kong Monetary Authority as well as the banks. And a large number of cases were resolved through this mechanism. We also had a regulatory intervention, so we had the HKMA and the Securities and Finance Commission intervene and work with banks directly to come up with a resolution, a proposed settlement that was a mass settlement, and most were satisfied with this settlement. And this resolved roughly 90% of the cases were resolved through this mechanism. So what this incident demonstrated was that there was a lack of any quick or simple or efficient means of resolving wide-scale banking-related disputes. The regulators were primarily concerned about ensuring compliance with regulatory requirements, but they really didn't have power to resolve disputes. And so they decided after this that there was a need to create a scheme or a system of financial arbitration or mediation to resolve these similar types of disputes if they should occur in the future. So we did establish a Financial Dispute Resolution Center. It's been in existence since 2011, roughly. And experiences were examined from the UK, from Australia, Singapore, as well as the US. So some of the lessons that were integrated into the design of this center, there was a need for a clear dispute resolution roadmap and a final decision with a final award was necessary. And also involving multi-tiers or multiple tiers was found to be quite efficient. So encouraging users to first try negotiation directly with the banks, and that in many cases resolved a good number of disputes, then offering either mediation or arbitration as a second and third tier. So the initial parameters of the Financial Dispute Resolution Center included member institutions, banking institutions that were licensed by the SFC and HKMA. The claim was had to be within or under 500,000 Hong Kong dollars within 12 months of the incident, and pay-as-you-use fee structure for these types of claims. So this is a chart showing the initial claim, the fee amounts, and how they were shared between banking institutions and individual claimants. So they received a large number of inquiries in 2012 and in subsequent years, and a small portion of cases were resolved through this means. And I serve on the Financial Dispute Resolution Advisory Board that deals with complaints, and this is seen internally as a very good result. So the fact that there are a low number of cases means that the information disclosure is taking place within banks. People know they have this option. There are inquiries that are being lodged, but the fact that there are a small handful of cases actually is seen as a good sign and a healthy sign that the system is working. And those that do need to address their claims, they do have a place to do that. There was some research that I did in 2013 comparing some of these systems, and what appears is that there is a general concern or consensus that a number of principles are emerging that are important to be considered in the design of these systems: independence, impartiality, accessibility, efficiency, and fairness. So these are some of the key concerns or principles that various systems are seeking to integrate. It also looks at how we might expand access through looking at the range of eligible complainants, and there are some suggestions in that regard, including increasing the cap on claims from 500,000 Hong Kong dollars to 1 million, expanding the claim period from the incident to the actual statute limitations period to 2 years, and then also lowering costs. So some of these suggestions were implemented, and as we'll see in a later slide, about 2 years ago, the Financial Dispute Resolution Center implemented the first two, which is it increased the award cap ceiling to 1 million, and it did increase the limitation period to 2 years. So what can we learn by looking around the world at various other systems? So again, in Hong Kong, we have the financial dispute resolution system. In the UK, we have the financial ombuds system. Singapore has a financial industry dispute resolution center. Australia has a financial ombuds service. So who is eligible to bring their claims? There is some variation. I think for the most part across the board, individuals and sole proprietors, for the most part, can access these centers or services. Australia does allow retail clients, including partnerships, corporate trustees, small businesses, to also access services. The UK includes trusts and charities in its eligible complainants. So some of the questions that a country or a community might consider are what would be the appropriate category of eligible complainants. Is it extensive? Does it cover the reality of the particular region? Whether medium-sized enterprises are included, this is an important consideration. In terms of the design of these systems, we find that in most cases there are at least 2 stages, and in many cases 3 stages of resolution. The first is a preliminary information stage where individuals can receive support and information on claim processing or dispute processing. They may have opportunity for direct negotiation with banks. Then there is a mediation, neutral evaluation stage, and then arbitration is often either the parallel or final stage. So what has been found across the board is that there are clear benefits for early case management, early case intervention, and a large majority of cases are in fact settled at this preliminary stage. Final decisions in the UK can be made without prejudice, so claimants have the option of taking their case to court. This is true of the Ombuds service in the UK. In the Hong Kong, the system is more of a final binding decision by the arbitrator. So the costs, there's variation. I won't go into too much detail, and I'll be happy to share these slides with you to have a bit more background on costs. In general, fees or some modest fee can be helpful in weeding out unmeritorious claims. So some sort of fee structure is important. So again, as I mentioned, there was a new rule development in Hong Kong. So taking into account some of the experiences over the past 8 years, some of the claim ceiling was increased, as well as the limitation period. So what are some of the benefits? Why are financial centers or other large cities considering financial dispute resolution systems in relation to banks? So the streamlined resolution process is attractive, avoiding lengthy, costly court hearings. Resolutions once agreed to by both parties, if they are created and co-created by parties themselves, have higher rates of implementation. And this has been found across the board through a number of studies. And then there's also the issue of cost and time savings. Those costs can be passed on to the bank in terms of increased revenue, or back to the consumer or commercial retail investor in terms of more creative solutions, more width or bandwidth for looking at alternative or future-oriented solutions, or back in terms of into the bank in terms of creating more attractive products for partners within the banking system. Okay, so what are some ideas or suggestions that might be considered in the short term that might be relatively easy to implement? One of the things that we've seen across in the jurisdictions I mentioned, Singapore, Australia, Hong Kong, as well as the UK, you do see that there are specialized lists or panels of arbitrators who have particular expertise in banking or financial disputes. And this could be very attractive to banks, giving banking institutions more confidence and certainty that the individuals or arbitrators who are dealing with their case have knowledge about financial law, contract law in relation to banks, insolvency issues. So specialized training for these individuals often goes alongside membership on these lists and can be quite helpful. So now there is an option to participate in a role play. This is just to give you a chance or an opportunity to see what it might be like to deal with direct negotiations. This is a case involving a financial product, an investment product, between two individuals, but it will give you a chance to practice some of the skills of reframing, basically identifying common ground and trying to identify options or possibilities for resolution. So you're going to be asked to divide into groups of 5. 2 of you are going to play the role of Hassan, 2 will play the role of Ahmed, 1 will play the role of the mediator. So before we go into this role play, I'm going to give you a little bit of background on direct negotiation, some concepts that you might consider when thinking about direct negotiation experiences or issues with in resolving financial related issues. So in terms of direct negotiations, a very important element is reframing. So again, I teach whole courses on this, but I'm going to give you a nutshell 5-minute version of probably the most important essential approach to negotiation, which is this idea of reframing. So what is it that both parties have in common? This is a question you want to ask yourself through the process. What is the conflict really about? What is it that you might share? So you both may have an interest in resolving the issue, developing strong business ties, continuing your relationship, moving forward, continuing to generate business together. So there could be a number of common issues, and taking time to think about that is important at the outset. So reframing involves asking this question: how can we meet your need for X while meeting my need for Y? So how can we address these needs simultaneously? So again, here it means moving away from position, I want X amount, or I want to see you go to jail, etc., to underlying needs. So how can we meet both needs simultaneously through reframing the issue from positions to underlying needs, and then you're able then to consider possible solutions and to generate a list of possibilities. So in the process, and here you're going to be engaging in some sort of facilitated or negotiated process. So for the mediator, the person who is serving as the neutral in your group of 5, you alongside both parties want to assist or help the participants to think about the issues to be addressed. So what are the key issues or concerns that need to be resolved in this case? What are the underlying needs of both parties? What are some options or possible solutions that might be considered? What are some criteria or standards for measuring these options? And you may come up with your own criteria, or there may be internal rules that you reference. And then final agreement. So again, this is a case of a financial product. It's something that is more from sort of 2 individual investors facing off. So this is a particular case that 2 investors may come upon, and will give you a chance to practice or think about how some of these skills of negotiation, mediation might be relevant to financial related claims. Okay, so again, you're going to meet in groups of 5. You're going to have 1 mediator, so 1 individual will volunteer in your group to help facilitate the conversation. You're going to have 2 on each team, so 2 again who are representing the character of Hassan, 2 the character of Ahmed. You're all going to receive general information. And then Hassan's group is going to receive private information, and Ahmad's group is going to receive private information only known to them. And you'll have about 10 minutes to review this material in your group of 2 with your partner. And then you'll have about 20 minutes following that to role play and to try to see within your group if you can come up with some resolution. And then in your group, you'll have a chance to debrief. So to share with each other how you think it went, and to finally, at the end, disclose any bottom lines that you had initially that might be of interest to the other side, and just think in general how this might be relevant more broadly to financial, commercial related matters. Okay, so it was a pleasure being with you virtually, and I wish your program much success, and I wish your small group mediation much success, and I look forward to hearing how things develop. Thank you very much.